Colleagues, it's the appointed time. We have a quorum. I call to order the meeting of the Bills Committee. Let's invite representatives of the administration to come inside the conference room. Welcome, representatives of the administration. Ms. Elaine Mack, Dr. Peng Fei Cho, Mr. Derek Lee, Mr. Dominic Ho, Mr. Emmanuel Lam, Dr. Winnie Au, Mr. Deidru Ms. Priscilla Poon, Ms. Natalie Lam, and Ms. Natalie Wong. We'll continue with the clause-by-clause examination. The Bills Committee at the last meeting completed scrutiny of the long title and Clause 1 of Part 1. Let's start from Clause 2 today. I also remind the Assistant Legal Advisor to draw members' attention to any potential legal and drafting issues. Mr. Derek Lee. Thank you, Chair. Let me first say we are going to amend the long title of the Supplementary Medical Professions Ordinance. We will amend, as we said earlier, Supplementary to Medicine of Allied Health to reflect our intent to amend Supplementary Medical Professions to say Allied Health Professions. Section 1. Subsection 1. We are amending the ordinance to say Allied Health Professions Ordinance. Subsection 2. We would say in Schedule 1 instead of in the schedule with effect from such date as the Chief Executive may appoint by order in the Gazette. So essentially, we are removing the part that says from such date as the Chief Executive may appoint by order in the Gazette, because the ordinance has already been applied to the professions, which is why we are essentially removing this part which is outdated. All right, please continue. Thank you. Section 2, interpretation, page 2 of the marked-up copy. Section 2 is about the interpretation. We will amend certain definitions. For profession, we will have it say Schedule 1 instead, because we now have multiple schedules. We will also amend the definition for registered. It is now Section 10. And we are amending this because some have had their registrations revoked and then their names are afterwards placed in the register again. So we are going to say entered in the register in accordance with sections 13, 13A, and 13B. Or because there are different types of registration, there are provisional registration as well as temporary registration, and the existing Section 13 already has the official registration, but because we now have different types of registration, we are including the other registrations. and that is section 15. We will touch on these sections later, so I can perhaps go into the details then. Next, certificate of registration. We are removing the part "and a certificate of provisional registration issued under section 15. I will talk about in detail what this amendment is. Basically, we are trying to simplify the provision. In future, we will not have a certificate of provisional registration, hence we are making this change. When we get to section 15, I'll talk about the details. Another definition is council. We are amending it to say Allied Health Professions Council established under section 2C. When we get to section 2C, I will go into details. Basically, we are changing the name of the council. We are also adding some new definitions. That is temporary registration and provisional registration. They will say see section 2A. I will go into the details when we get to section 2A. Designated institutions, see section 2B. Again, I will talk about details when we get to section 2B. As for specified form, we have a new definition as well. A form specified by the Council under section 33. When we get to section 33, I'll provide more details. We also have a definition for the Chinese Medicine Hospital of Hong Kong. Last week, we gazetted number 15 of 2025, the Chinese Medical Hospital of Hong Kong Ordinance, and Chinese Medical Hospital of Hong Kong would have the meaning in this ordinance given by section 25 of the relevant ordinance. Let me go on to talk about the amendment in page 3. Subsection 2, we will amend the schedule to say Schedule 1. Because, as I said earlier, we have now multiple schedules. I'll perhaps pause here to see if there are any questions from members. None. Please go on. Thank you. The next amendment is on page 5 of the marked up copy. Page 5, we have new sections 2A and 2B. Added after section 2. These are the new pathways for registration. So basically, we have the definitions of full registration, limited registration, temporary registration, and provisional registration. Full registration is an existing registration pathway, and we will amend the name to say full registration. We have the new pathways, limited registration and temporary registration, sections 13A and 13B. For professional registration, it is also an existing registration pathway in section 15. We will retain this pathway for those who are qualified under the professional registration pathway. As for section 2B, it is about the institutions who are qualified to engage those who have limited registrations. I will go into details when we go to the relevant section. But basically, it means institutions who are able to engage those with limited registration. I want to ask, so this will not be subsidiary legislation, right? So this will not be subject to negative vetting. That of Section 2B correct. For Schedule 2, not all of it will be subsidiary legislation. Most of it will be subsidiary legislation, but basically, institutions may be designated as a designated institution by the Secretary for Health by notice published in the Gazette. The notices will not be subsidiary legislation. I will provide more details when we get to the relevant section, but this is the arrangement that is applicable to nurses as well. Apart from the institutions that are already designated, we want to offer some flexibility to the Secretary for Health to designate some designated institutions that can engage those with limited registration. Thank you. Please go on. I will now draw members' attention to page 6 of the marked up copy. We added a new section 2C. We are trying to amend the name of Supplementary Medical Professions Council to Allied Health Professions Council. This is to reflect that the professions are not supplementary in nature. So in subsection 1, we will amend the names of Supplementary Medical Professions Council in English and Chinese to say Allied Health Professions Council in English and Chinese. We will also have subsection 2 to say, despite the amendments to the relevant section, the authority of the council will not change, and their committees appointed will still be valid. These will come into effect sometime later, as I said earlier, because we want some more time for the government to appoint personnel. So this section 2C will come into operation later. Ms. Chen Huayan. I have no problem with the section in particular, but as we said earlier at the first meeting and during the public hearing, some deputations had another suggestion. They don't really want the name Allied Health Professions. I can see in 2C1A it still says Allied Health Professions Council. Do you have any plans to change this name hereafter, after listening to feedback of the professions? Well, we are inclined to retain this name because in the HA, they still use the term Allied Health Professions to refer to the relevant professions. We do note such feedback being given during consultations, but most of the stakeholders consider the term Allied Health Professions accurate. I'm sorry. I think the administration would have to provide a proper response to the views of deputations, because the general feedback, I believe, is to amend this. I think as long as you have a response that says people accept Allied Health Professions in English especially, because I think they're alright with the Chinese term, but not the English term. Thank you. Alright, please proceed, Mr. Derek Lee. Thank you. Section 2C is set out on pages 6 to 7. I will now draw members' attention to page 8 of the marked up copy. For section 3, there are some amendments. There are quite a number of amendments. So let's talk about some parts and then we'll take a pause and move on. Section 3. For the composition of council, we have some changes. Subsection 1. For the new members, there are some changes.
Where the chairman is the same. That's 1A. The chairman will be appointed by the chief executive. 1B, a deputy chairman appointed by the CE. Now, this is also appointed by the CE, but this is a specified officer. That's in the new 1B. Specified officer, we're going to be talking about these when we come to Section 5. There's some public officers, hospital authority officers, and the officers of the PHCC. The deputy chairman, since 1993, used to be the deputy director of the DH. We think that this arrangement can be kept on, but with a flexibility. Other than the Department of Health, we should also include the hospital authority and also the PHCC. One C, not more than 4 specified officers appointed by the chief executive. So here, instead of public officers, we put specified officers, and they are public officers, hospital authority, and the PHCC personnel. 1A, Roman 1 to 3, the CUHK, PolyU, and HKU will make the appointment. Now, 1B, the chief executive will appoint 3 persons being specially qualified to advise the council on professional education. So allied professional education is not confined to these 3 institutions. There are other self-financing organizations or institutions. There are also training personnel there. So we'd like to broaden this out to cover all of them as well. And 1D4, 1 person appointed by the chief executive from each profession. This will remain unchanged. That's in E. Also, in the existing provision, 1D5, Roman 5, 4 other persons not being public officers appointed by the chief executive. Here we change this to 4 persons other than registered persons appointed by the chief executive, and they are lay people. So 1F, G, H, these are new. 4 persons other than registered persons, and 1 registered medical practitioner and 1 registered Chinese medicine practitioner, all appointed by the chief executive. And this would foster the cross-sectoral collaboration. We're also making the proposal for the CMP to make referral, and it makes sense to have a representative there on the council. Page 0008, 1A, a member appointed by the chief executive holds office for 3 years. Oh, sorry, omitted 1 point. I, the chairman of the board for each profession. Now, there are 5 airline professional boards, and their chairman will be represented on the council as well. Sorry, Chairman, let me come back to the new 1A. a member appointed by the chief executive holds office for 3 years or such lesser period as the CE may specify in the appointment. So basically, 1I, other than this, chairman of the board for each profession, all members will be appointed for 3 years. As for the chairman, it would be the same as the tenure of the chairmanship. And when the tenure expires, the chairman's membership will also expire. Perhaps I pause here. Mr. Chen Pui-Leung. Chairman, thank you. Specified persons, I don't think there is a definition there, is there? In this provision, when I read this term specified officer, I would be a little puzzled. Would you reference that to the later provision? Thank you. Maybe I didn't make myself sufficiently clear. I'm saying that it doesn't appear on 0008. There is a definition on 0009. That's in 3.5, section 3.5. There is a definition for the specified officer. They are public officers and also officers from the hospital authority and also the PHCC. They are the people from these 3 sources. This is linked up with the later provisions. Yes. Mr. Tommy Zhang, Chairman. Here, the member will hold office for 3 years. For many boards or councils, there would be a tenure of 6 years. And there would be a reshuffle after 6 years. Does it apply to this council? After 6 years, there will be no more appointment of the member. Is that right? Yes, indeed. Deputy Secretary, indeed, Chairman, this also applies to this council as well. Yes, please. Mr. Bill Tank, Chairman, thank you. I'd like to clarify one point here. Specifically, there is no amendment to the chairman. What is the nature of the chairman? It doesn't specify who can become the chairman. He doesn't have to be from the 5 professions. It doesn't have to be public officers. So when implementing the policy, what is the nature of this membership, of this chairmanship? And also qualified, specially qualified to advise on professional education. Specially qualified, how do you interpret that? Or do you interpret that by common sense? Basically, in most cases, they're appointed by the chief executive, with the exception of I, meaning the chairman of the board from each profession. Would they be in step in terms of the tenure? Chairman, for the chairmanship, it doesn't specify whether it is public officers when the particular people, the chairman doesn't have to be from any of the 5 professions. The current chairman is not from either any of the 5 professions. It all depends on the leadership and the competency and so on. We will arrange for the suitable person to take up the chairmanship. As to the tenure, it may not be in sync. The chairman has got a point there. We will have regard to the arrangement of the members, and the tenure might not be in sync entirely. That's quite right. Specially qualified, thank you very much for the question. And this is not the first time this has appeared. When we come to Section 5, this has always been there. So the interpretation is that the relevant institutions are or have the experience of teaching this particular profession, and we are using this to interpret the term. And as I said, this is not the first time this has appeared. We would interpret this in the usual way when making the appointment. Please, thank you. Will members please refer to page 0009, section 2. Members appointed by the chief executive may be reappointed upon expiry, and that's from A to H. I is not included. As I said, they are the chairman of the board, and the tenure would be consistent with the board's tenure. 0009, clause 3 and 3A. That's about the resignation of the members. And we are making this aligned with the board. A member who resigns will have to make written notice to the chairman, and the chairman will have to give notice to the chief executive. The chief executive may remove from office and a member appointed for permanent incapacity or other sufficient cause. Now, it's entirely up to the chief executive to decide on this one. And also on the same page, there are some changes. We add one or more legal advisors. And this is to enable the council to have more than one legal advisor. The same arrangement is made in the nursing council and the dental council. And there is a need for a legal advisor, and we don't really want to limit this to one single legal advisor in light of the sheer workload. And also in Section 3, other than the point about the legal advisors, all the other provisions will come into effect on the 1st of January 2026. As we said, I would like to leave more time for the new members to be identified. If I may also say that in connection with Section 3, the legal advisor raised the point. We have already addressed this in our letter. Now, 3.1e, a member from each profession, that the legal advisor is asking whether the person should possess the certificate of practice. Now, for nursing council and the dental council, there is such requirement for the professional members. We've already explained that for the dental council and the nursing council, the composition is somewhat different from the allied professions council, because the members here are appointed by the chief executive, and the CE would have regard to the background of the members. But when it comes to implementation, 10C, Section 10C, we would make the point that within 6 months, if one hasn't got the certificate, the appointment would lapse. So even if we do not make it clear that one has to have the certificate of practice, it will achieve the same purpose. So when it comes to implementation, the professionals would possess the certificate themselves.
呢個問題
Perhaps I'll pause here. I have a similar question. It says that one in each profession will be appointed by the chief executive. So it may be a professional, say in academia, without any valid registration, right? Well, we will try to have people who have a valid registration currently. But we would not say, and we have not said, that it has to be someone who has a valid practicing certificate. Ms. Lillian Kwok, I have concerns about this because it may be a non-professional governing the professionals in the end. We have many government committees actually have those who are not in the specific professions governing those in the professions. It is not ideal. I also want to draw members' attention to page 8 of the marked up copy. A deputy chairman being a specified officer appointed by the chief executive. So we used to have ex-officio members on top of some professional members. What is the ratio in the council for this? Will you set a ratio if you don't have one? Because we have in some government committees the ratio being 50-50. That is not exactly reasonable even to the public. Will you consider setting a ratio in law? Even if it is not in law, can you provide more details in the administrative guidance? Thank you. Deputy Secretary, I do understand the members' concerns. Right now, for specified officers, it would mean a public officer, a person who holds an appointment at the hospital authority or at the primary healthcare commission. We do have the numbers set, including the deputy chairman. We have in total 5, and the number of members in the council in total is 25. The composition for specified officers is essentially the same as what it is now. We want to include specified officers to say also persons who hold an appointment at the hospital authority or the primary health care commission, because we want more professionals who are relevant. I do note what the Deputy Secretary said, that the number has not changed. But you didn't say the other members who may be appointed cannot be public officers. I have seen some committees that do not say their composition having to be mostly non-public members, and it in the end would mean there are a lot of public officers on the board. Deputy Secretary. Well, in general, for the council and the relevant medical professions board, it has been quite clear. It would say in particular how many public officers or specified officers there are. For the representatives of the specific professions, we will not have public officers appointed. in those posts. Alright, I understand what you're saying. For those other than the specified officers, for the other posts, if they are working at the hospital authority, would they be excluded? Well, if they hold a public post, they will be considered a public officer. They will not be considered a professional of the sector to be appointed. Alright, I think you need to make it clear to the sector. There should be communication on this. Thank you. Alright, please proceed. Thank you. We already talked about what is on page 9 of the marked up copy, and now draw members' attention to page 10 of the marked up copy. Section 4, Purposes of the Council. These are essentially the current arrangements. In subsection 1, it says the purposes of the Council shall be to promote adequate standards of professional practice and of professional conduct in the professions. B, to coordinate and supervise the activities of the boards established. In subsection 2, it says the Council shall perform its function of coordinating and supervising the activities of the boards by making to each board or inviting the board to make to the Council proposals as to the activities to be carried out, by recommending a board to carry on such activities that as the Council considers appropriate, etc. And we have added a subsection or a paragraph E under subsection 2 to say the Council should perform its function by providing a board with steers or instructions for better carrying out the purposes of the Council. So this will essentially give the Council more power in providing oversight. Please continue. Thank you. Page 11 of the marked up copy. Section 5, Establishment and Composition of Boards. It's just like what we have in Section 3. We will have one or more legal advisors that will come into operation later. We have in the provisions of Section 5 arrangements that will come into operation on 1st of January 2026. Let me go into the specific provisions here. Subsection 1, for each profession there shall be a board consisting of not less than 9 and not more than 12 members comprising the following. This part will be deleted to say only the following members. We will also delete the part about a chairman appointed by the chief executive from among the members of the Council other than a member. And it will say in future, as set out in page 12 of the marked up copy, in subsection 3A, the chairman of a board is appointed by the chief executive from the members of the board and holds office for 3 years or until the chairman ceases to hold office. It may be the case that they may resign, and the specific provision for resigning is found in subsection 3B. We also have back in subsection 1 paragraphs B and C. These members would have to be registered medical practitioners. One of them would have to have their name included in the specialist register and nominated by the Hong Kong Academy of Medicine. This is to make sure we have a professional representative on the board. We also have in paragraph C, that is actually an existing arrangement, a registered medical practitioner nominated by the hospital authority and appointed by the chief executive. And we also have in existing provisions, one person being a registered medical practitioner appointed by the chief executive on nomination of the Hong Kong branch of the British Medical Association. Since 1997, the position is left idle, which is why we are deleting this part. As for paragraph D, this is unchanged, essentially, but we are making some minor amendments. We will also add a paragraph F, with paragraph E remaining unchanged. Paragraph F is about how we will have two persons not being persons registered in the profession of that board appointed by the chief executive. This is new. We have in section 1A some provisions on the term of members of the boards. A member appointed by the chief executive holds office for a period of 3 years, or a lesser period as the chief executive may specify. Please continue. Thank you. For section 3A, we already touched on this earlier. That is about the appointment arrangements of the chairman of a board. And section 3B, again, we touched on this. The chairman of a board may at any time resign the chairman's office by written notice to the chief executive. Right now, we say members should resign their offices by notice to the chief executive. In subsection 3, we are amending it to say chairman of the board. This arrangement is consistent with that for members of the council. The chief executive may also remove from office members of boards for permanent incapacity or other sufficient cause. This is an existing arrangement and we are retaining this arrangement. Please pause here. Ms. Chen Hoi again. Excuse me, I want to refer to an earlier provision. I was digesting the contents. Section 51C. One registered medical practitioner nominated by the hospital authority and appointed by the chief executive. Before we have in G, we have already or D that should be nominated by the hospital authority and appointed by the chief executive, as well as the Chinese medical practitioner. Well, the Chinese medical practitioner actually refers to the arrangement in section 3. Oh, sorry, I had a mix-up. Ms. Lillian Kwok. I want to ask, so we have for some boards, there will be a cap on the terms of members. Say they can only serve 2 or 3 terms. Will you set a cap for the terms of members? Thank you, Mr. Derek Lee. We have in the provisions a term of 3 years, and while we don't say that there is a cap, in general, members can only serve for 6 years, as is the case for other government committees, unless there are specific circumstances. I think we do not have to spell this out in law, but I think we can include in the administrative guidance this cap on terms of members. Well, this is actually a general rule for the government for advisory bodies. This applies to all policy bureaus. And in general, when we make appointments to, say, medical professional boards, we do follow this rule, essentially. But we do want to retain flexibility. Should there be special circumstances, members can serve for over 6 years. But this is an exception. Thank you.
Please. 0012, there's Section 4. Like the council, here we specify one or more legal advisors, and this is to reflect the workload of the boards. As we're going to point out later, the legal advisor will have to deal with the disciplinary matters, and there is a need for more than one legal advisor. Mr. Chen? Chairman, I'm a little bit confused. For the board members, they are appointed by the chief executive, but for resignation, the resignation is by written notice to the chairman. So would that come into effect as soon as a written notice has been given, or does it have to be approved by the chief executive? PAS, if a member makes the notice to the chairman, it would have effect, would be effective. So it would be the same as other arrangements, and the fact that they're appointed by the chief executive doesn't mean that the resignation has to be tendered to the chief executive. For the important posts like the chairman or deputy chairman, it would be by written notice to the chief executive. But for members, a notice to the chairman would suffice. There is an exception here for PIC if one is in the process of the PIC, the resignation will be held off. PS, Chairman, indeed, if the PAC or PIC is in progress, then the chairman can ask the member to stay on until such time as the PIC is completed. 0012, the composition of the boards, that's the end of this. We move on to 0013. That's the purpose of the boards. In Section 6, A and B says the boards are to promote adequate standards of professional practice and to carry out functions assigned to it under this ordinance. Now we're adding one purpose here, and that's the new bracket C, to carry out any function assigned to it by the council for better carrying out of the purposes of the council mentioned in Section 4.1. Now in Section 4, we've added the provision that this is to provide advice and steer to the chairman. This is to tie in with that particular new provision. Please. If members may refer to page 0014, there is an executive arrangement and that is changed. We've changed the membership of the council and the boards, and we're changing the quorum here. For the council, now it is 6. It's going to be increased to 8. And for boards, the quorum is 4 members. 0015, we've added 9A. 0015. Yes, on 0014, I've got a question there. 7.3. In absence of the chairman, then the deputy chairman will act in his place. And if the deputy chairman is also absent, then those members present shall appoint one of the members to act as chairman. Now, how is it going to happen? It doesn't specify how the appointment is going to be done. P.S. But the members of the board who are present will be casting the vote to elect the chairman. So it's somewhat different to other ordinances. Normally they say elect instead of appoint. Now in terms of quorum, 8 and 4 for the council is 8, boards 4, no problem there. But for the boards, they have the function of holding hearings. If the board is holding a hearing, would the quorum be still 4? And there may be a lot of members sitting on the board. And you need to have all the members there for it to continue, otherwise it will be hard to reconvene. Now, if there are many members on the board and they cannot sit on the next board meeting, would it be the same arrangement? Yes, Chairman, we haven't made any change to the arrangement of the hearings. The hearings will be the same as the meetings when it comes to the quorum. Professor Chen? Now, 4 members being the quorum for the hearings, and you have different members. You also have lay members, or do they have to be members from the allied professions? Would it be biased if they are all allied professions? And normally you have some lay persons to make sure that the hearings will be conducted in a fair and just manner. And is to follow up on the chairman's question. Normally, by reference to other boards and councils, you have people from the professions and also the lay people sitting on the board. P.S. If I may address this first. Now, for the board hearings, they don't have to take the decision straight away. And after the board hearing, there would be deliberations, and a decision that will be made later on, and members will be able to refer to all the documents and all the representations made and evidence given by the respondents. They don't have to take the decision on the spot. If there are no lay persons, and it would not have any material difference made to the situation. Chairman, prior to the hearing, all the documents would be made available to the members. So the members would make preparation beforehand before attending the hearings. So the members will form their own views regarding all the basis of the documentations, and there are deliberations. Professor Chen, a simple follow-up, if I may. Everything is in the public domain, and the airline professional would have to attend the hearing to make representation, or maybe he or she will be represented by counsel. And if you have different members on the board, that this time maybe I have 4 members, and next time another 4 members, and there is no continuity, and it doesn't seem to be an appropriate arrangement. So I, like Chairman, am concerned about this. I like the Chinese medicine practitioners hearing. We have the members from the profession and lay people to complete, same members to complete the entire hearing. And it's not the case that we would refer the documents to all the members afterwards. Yes, Chairman. For the boards, they don't have any lay members other than the chairman. That the chairmanship is taken up by a lay person, but other than that, they don't have any lay members on the board. As we said in this clause-by-clause scrutiny, in the composition, we're making significant changes by adding 2 lay members. Now, with these new lay members, then the composition of the hearings can have regard to what Professor Chen has to say, and they may make some adjustment. With 2 lay members there, I'm sure that they will have a lot of flexibility and room to align with other professions. Professor Chen, well, it's only now that I realize that the chairmanship is not taken up by the professional. So for these airline profession boards, and the chairmanship is taken up by a lay member. And now you said that they have no lay members on the board, so the chairman is only the person who is a lay member. Now we have to make progress with the airline professionals. We hope that the council and the boards of the profession the chairmanship should be taken up by the professional. And on the boards or on the council, there can be lay members. I'm not familiar with other boards, but for the Chinese medicine, we have the chairmanship taken up by the professional. We do have other lay members as well. So in terms of professional supervision, we do have the professionals as chairman. So from the council and the boards of the profession, the chairman are not really from that profession. And the only lay people are the chairman of the board. So the lay people will be supervising the professionals. I doubt whether we will be able to come to any fair and just judgment. Yes, Chairman, thank you. What Mr. or Professor Chen is saying is exactly what the legislation means. The chairmanship is taken up by lay people. So the chairman is appointed to the council. Now for the boards, for the individual boards, they don't have any lay members. That's the current situation. But you have a doctor, yes, with the exception of the medical practitioner. That's the current situation. So we're reviewing this arrangement or this composition and really want to make some changes. I would like to add lay people, 2 lay members other than medical practitioners. And for the council, the chairman will be appointed from the boards. They are mostly members from the professions. So when we choose the chairman, chances are that we have someone from the profession instead of the lay people.
Mr. Tankapu, I think in public administration, or say from a corporate governance perspective, this is a topic that is often debated, whether we should have a professional in the profession governing the professionals in the profession, or should we have a lay person governing the professions or the professionals in the profession. I understand what members said. We have 5 professions here. If we are to have someone who are in the professions or someone in the sector elected a chairperson, it may not be accepted by the representatives of the other professions. So I am thinking maybe a lay member who has extensive experience in public administration elected a chairperson may be more acceptable. For the chairman of the council or the boards, they do not have extensive power. They only preside over meetings. They are just trying to strike a balance between demands of and needs of patients as well as needs of professionals. I am not in the medical profession, but I support that physiotherapists should be able to provide direct access services because this will lower the costs of citizens in getting treatment. Please rest assured, I will think in favor of someone even if I am not in that profession. I think members should understand that people think this way. With this new structure, I believe members should be able to exercise the functions intended. Well, I would say for the disciplinary hearings, the members of the panel should be members in the specific profession. There shouldn't be any members from other professions on the panel. This is just a clarification. Yes, Professor Cheng Wen Kwong. I just want to make a clarification. We now have in the Allied Health Professions Council a registered CMP, which I appreciate. I also agree that a non-profession to be elected chairman of the board may be undesirable because they may not understand the needs of allied health professions as much. I think it should be someone from the allied health professions so that they will understand the needs of the professions better. It doesn't matter if it is just a professional from a particular profession being the chairman, because I don't think they will be biased towards their particular profession. I just think it is better to have someone in one of the professions because they will understand the needs better. Say, for the Chinese Medicine Practitioners Board of the Chinese Medicine Council of Hong Kong, we have a CMP elected as the chairman of the board. So why do you need to adopt a different approach for allied health professions? Deputy Secretary, we do understand your feedback. We are making a change, therefore. We no longer need to have a lay member be the chairman of the board. We do not specify that it has to be a lay member, unlike before. So it can be a professional member becoming chairman of the board. Ms. Lillian Kwok, we have all along heard feedback that there may be some non-professionals governing the professions. But I also understand what Mr. Tang Ka-Pu said. I'm just saying maybe you should set a ratio of professional members and lay members. Say in universities, they have a 7:3 ratio. I think we can strike a balance protecting the interests of the professionals as well as other stakeholders. I think with a set ratio for the composition of members, it doesn't really matter who the chairman is. If you have a high ratio of lay members, I think it will help us strike a balance between the different interests. What is the administration's stance on this? I would say this. They have already set the composition or the membership composition essentially, but I think they can make some adjustments to the ratio. Mr. Derek Lee, I think for the council we do want to have a more macro perspective, which is why the council has a high ratio of lay members. As for the boards, they are specifically for the professions. Before the change, we have 12 members, and we have 3 members who are lay members and 9 who are professional members. In future, we will have more of a balanced representation so that they can take a more macro perspective in coordination. With the changes in the legislative amendments, we will have a similar ratio. The council will have a ratio of 12 to 13. So in the council, we have a higher number of lay members. For boards, we want to have more professionals. Well, I can share with you my experience. For the medical council, we have it used to be the case that for hearings we had to have 10 odd to 20 members take part in a hearing, but when there was a change of term, it would be hard because we need to have so many members attend the hearing, and the hearing cannot be held often because we have to deal with the other members' commitments. We have seen with changes in legislation, we have lowered the quorum. We also have a roster for members to attend hearings, and after that we actually have specific panels formed on each occasion for a hearing. But now you're referring to the old approach of the medical council, and I anticipate that there may be issues. So this is just an experience I want to share for the administration's reference. I want to also say for section 5, it says that the chairman has the casting vote. I think you should specify, in particular for hearings, the chairman should not have the casting vote. I will let the secretary supplement my answers, but I understand that when the votes are in equality, there should be a casting vote. Well, I want to ask, are you talking about the equality of votes before the chairman has cast their vote? In this section 7 in particular, it says that the chairman has the casting vote. I think there's some confusion. If necessary, you should make amendments. We can perhaps refer to the provisions and we can provide a response to the chairman later. Thank you, Mr. Lin Kwok. I would like to thank the administration for responding to the chairman's questions. This is a very much valid concern because hearings can really impact the professionals. I think, of course, the composition of the hearing panels should involve professionals. There should be one or more legal advisors. There should also be a set ratio for professional members and lay members. I think you need to really set that out clearly to show that you are striking a balance between different interests. Of course, we don't want too many professional members because we want things to at least seem fair. It's just like on juries, we wouldn't have lawyers on the juries. So we need to show that there is authority in the sense that we would not have only those in the professions making decisions at hearings. I think you need to tell people what the composition of the appeal or the panels are and the ratio of members. We can provide a response later. The secretary said earlier, in general for hearings, the secretariat's arrangements are that they want all members to attend. For the composition of members of boards, we have mainly professional members. We do have some lay members. We want to make sure hearings are fair by doing so. But I note the members' concern and we will provide a response after we review it after the meeting. Thank you, Professor Chen Wing-Kwong. I want to ask about Section 7, subsection 2A. You say at any meeting of a board, the quorum is for members. According to the administration, they want all members to attend. But then the quorum is just for members. If you have different people attending, it may be an issue as well. So it doesn't say exactly that you want all members to attend the disciplinary hearings. I think you can provide a response later. I think it's different from the arrangements of the Medical Council of Hong Kong. They do not have that many members on the boards of supplementary medical professions. I would say this as we see developments in the professions. It may be hard for you to anticipate what happens. Well, I'm sorry, we are not exactly familiar with the hearing procedures of the boards because there weren't that many of them. let us review the procedures and then we will provide a response to members. We will also ask the SMP Council to review the disciplinary hearing procedures of the boards to see if there has to be any change made to the procedures. Before we only have registered medical practitioners, we do not really need to think about the composition in future. Let us review this and we will respond to members' concerns. Ms. Lillian Kwok.
我都係
Ms. Lilian Kwok, Chairman, you say that the number of hearings may not be high. It doesn't mean that we do not attach importance to that. For the professions, a fair hearing would be of utmost importance. For the NGO organizations, they do have the disciplinary hearings, and they have the list of members attending the hearing. Earlier, we discussed the dental council, and there are also the arrangements. I think we have to reference all of these. And a supplement? DS? Chairman, I agree. I mentioned the numbers, that there's only 4 members reference. We agree that it doesn't matter whether the number is high or low. The transparency, the reasonableness and legitimacy will also be just as important. For these allied profession boards, they differ among themselves, but we will have regard to the other provisions and improve that. Section 8, not in the blue bill, Section 8 is about handling business by circulation of documents. If members does not agree with the circulation mode, what's gonna happen? Or does it mean that if there is an objection to circulation, then the meeting will have to be convened? Chairman, at the present moment, there is a box for the members to tick to indicate whether they'd like to have any discussions at a meeting. If a member were to tick this box, then the meeting will have to be convened. If there is an objection, even if there is majority vote, the objection will be reported to the chairman. And even if there is a majority vote, the chairman would have to decide whether a meeting would be convened. So there are 2 mechanisms. Number 1, there are a box to tick, and number 2, if there is an objection, it will be referred to the chairman or the secretariat for this to be handled. Yes, Chairman, I think you are concerned about the consistency in the law. We'll have a look at this and see whether CSAs would be warranted. Yes, please. If I may refer to the marked up copy, 0015, there is a new section 9A. If the Secretary for Health, in formulating the healthcare policies, he may request the information for that purpose. Now, by way of background, last year when we amended the legislation regarding nurses and dentists, we made similar arrangement for nurses. There is new 4B, and for dental council there is the new 5B. We notice that there is the manpower projection for the healthcare manpower. This is the input is on a voluntary basis. So in the future, we'd like to make this clear in a specified form. We would ask the registered person to make available the information to the council and the boards. And we're also conferring the power on the Secretary for Health to request the information for the formulation of health policies. So this is intended to make sure that the government will have reliable data to base on in the formulation of policies. And this is important for the planning of healthcare and manpower, like we did in the amendment to the Dental and Nursing Council Ordinance. This has to be in the public interest. This has to be relevant to the healthcare policies when the power is invoked. And in 9, Section 9, this is appointment of committees. It doesn't specify what committees here, but in S29A, it refers to the formulation of PIC. Now here, Section 9, the Council may set up any committee. It would decide on the composition, but in 29, the PIC would be more stringent in relation to the formulation. Do you have to add that other than the PIC here? Well, I defer to the DOJ. Our understanding is that in Section 29 1BA, that's what you referred to in connection with the PIC. In Section 9, it doesn't apply to the PIC. With PIC, we'll have to refer to Section 29 1BA. Legal advisor, Chairman, if I may add, in 29 1B, this is an empowering provision. It doesn't refer to the composition. Under the subsidiary legislation, it can specify the formation of the PIC. In the subsidiary legislation, 359J, physiotherapists, for instance, Section 17, it spells out the formation of the PIC, the composition of the members. Our understanding is that for this PIC, the formation is under the law. I mean, the power is conferred under the law. So this is somewhat different to Section 9 here. So we don't have to specify other than PIC, right? Mr. Chen Pui-Leung, Chairman, if I may go back to Section 9A, the provision of information. Now here it says may provide any information to the Secretary for Health, and that's in relation to policies. Do you have to specify that in more specific terms? DS or PAS? In Section 9A, what we're seeking to do is to make sure that it's relevant to the formulation of health policies. So this is the information requested for the formulation of healthcare policies, and the Council and the boss may need to provide that kind of information. So this is relevant, not any kind of information, only information that is relevant to the formulation of healthcare policies. And the provision confers upon the power on the Secretary. Mr. Chen. Well, when reading this, it sounds a little bit unspecific. Yes, Chairman, if I may, like the member said, that the purpose is sufficiently clear. Now we're saying provide any information. That's because it would be hard for us to be exhaustive about the kind of information that would be requested. So we'd like to couch it in broader terms, as long as it is relevant to the purpose of formulating healthcare policies that will be included. We don't really want to be too prescriptive. In other medical professions ordinances, we adopt similar provisions. For consistency's sake, we keep the drafting here in this section. All right, please carry on. If I may refer members to page 0016 of the marked up copy. On this page, it is about section 10. There are some changes to the existing provision, and we add some new provisions. Section 10 is about the separate register for the professions. 10(1) and 2 says that each board shall cause a register to be kept, and the secretary will keep or maintain and keep custody of the register. In section 1 or 10(1) and 2, there is a specified form. So in the regulation, we do specify the specified form. There must be the name, the photo, and the qualifications, the credential, and so on. Recently, for the healthcare professionals, we did amend some of the legislation, and we tend not to use or spell that out in the law. We would have this in the subsidiary legislation for the boards and to specify the form. When we come to section 33, we would go into more detail about the specified forms. Now, if we have the specified forms in the subsidiary legislation, we don't have to amend the law, and we don't have to amend the legislation, and there would be more flexibility. So in section 10(1) and 2, what we're changing is for the specified form, like the name and the addresses and qualification, we delete them. Instead, we put in specified or the particulars as specified by the council, and that would leave more flexibility to the council and the board to handle the business. Please carry on. Subsection 3 onwards, the secretary may make amendments as made necessary by the decision of the board. And in subsection 4, the details are set out there. The board may direct the removal from the register of the name of any person. And we're making some amendments there to subsection 4. People fulfilling the following criteria can be removed. So 4A requests in writing that his name be so removed. Basically, this remains unchanged. B, the person is deceased, and we've added BA to subsection 4 that whose registration is no longer in force. That's in connection with the limited registration and the provisional registration, that they will lapse after the expiry of a certain time. So we add BA, but the person whose registration is no longer in force. And we've deleted 4C, being a person required to be the holder of a practicing certificate and has practiced in Hong Kong for more than 6 months without having obtained such a certificate. Now here we amend this to read the person who has failed to obtain a practicing certificate within 6 months after the date of registration or after the expiry date of the last practicing certificate issued to that person. So basically they are the same in meaning, although we try to spell that out in no uncertain terms. And it would avoid the impression that one can practice without the practicing certificate. And 4D is not practicing his profession in Hong Kong. We propose that this be deleted because we have added 4C, a person who has failed to obtain a practicing certificate within 6 months. Now, if he's not practicing in Hong Kong, then this would address this. So 4D can be deleted.
In paragraph E, we have made some changes. It says here it has not supported the Secretary of the Board with an address in Hong Kong at which all notices from the board may be served on him. This is basically the same. We are just making some textual amendments to say who has not supplied the Secretary of the Board, and so on. We made another amendment in paragraph E to remove the part or telegram. The whole thing would say, provided that any person failing to acknowledge within 6 months of the date of dispatch the receipt of a registered letter addressed to him at the last address supplied by him to the Secretary, shall be deemed not to have supplied the Secretary with an address under this paragraph. Please proceed. In subsection 5, we have amended the subsection to say if the name of a person with full registration or provisional registration is subsequently removed from a register under this section or section 22, the person may apply to the board for the restoration of his name to the register, and the decision will be made by the board. We are amending this subsection to say that this only applies to those under full registration and limited registration. The assistant legal advisor asked in particular why this subsection does not apply to limited registration and temporary registration. It is because if one has not provided an address to the board or failed to obtain a practicing certificate within 6 months after the date of the person's registration or the expiry date of the last practicing certificate, one under limited registration or temporary registration would have to apply for a registration or anew. So it is why we have excluded them from the relevant arrangements. These arrangements are the same as those for nurses. Temporary registration would not apply either because temporary registration would last for only 14 days. So if their names are removed from the register, they need to again apply for registration anew. Alright, I don't think it spells out the procedures of restoration here. Are there any procedures for reviews to be done if someone is aggrieved by the decision made? Secretary. I would say this. Right now, the persons would have to fill in forms and then submit the forms to the Secretariat. The Secretariat would then forward the forms to the boards for consideration. I don't think you spelled out the procedures in the provisions. You do not even specify the deadline. So, for, say, different types of removals of names, say if it is a permanent removal of one's name to the register, would one be able to lodge an appeal? Well, actually, according to the Secretariat's website for the Optometrists Board, they have in particular a form for this purpose. Indeed, it doesn't say that how long after one's removal from the register that they can apply for restoration of their names to the register. Well, there are also other categories. Say for those who have committed crimes elsewhere, we also ask them to be declared. So that is the general procedure. Yes, Deputy Secretary. Because this is administrative in nature, we have not spelled that out in law. We will review the arrangements after the meeting. Perhaps we can refer to the practices of the Medical Council to see how they have the relevant arrangements spelled out in law for the restoration procedures. Well, I would also like to draw your attention to any procedures may be changed as appropriate. And it says here, the registration or application for a practicing certificate, the board may, subject to any conditions that it considers appropriate, approve or reject the application. So essentially, that would mean the board may impose conditions on the individuals when names are restored to registers. Correct. Well, let me go back to subsection 4. The assistant legal advisor asked another question about the existing section 10(1) and 2 of the ordinance. That if a practicing certificate, regarding the practicing certificate, that we have already provided a reply. Next, on subsection 6, on page 17 of the marked up copy, a register may be inspected without payment of any fee during usual business hours upon application to the Secretary of the Board. We have made an amendment here to say other than the part in relation to temporary registration. We have made this amendment because this is the amendment for nurses and dentists as well. The assistant legal advisor asked for the reason why we have to put in this amendment. We will go into details when we get to the relevant section, but basically, temporary registration is for individuals who are not here to provide treatments. They are here for clinical exchanges or education purposes. So there is really no need for their names to be inspected, which is why we have put in this part. Ms. Yong Ho Yen. I do understand in subsection 4, paragraph D will be removed and essentially it will be replaced by paragraph C. But I am confused. For one to obtain a practicing certificate, do they need to declare that they are only practicing in Hong Kong? How can you tell that one is practicing their profession in Hong Kong? If one is practicing their profession in both Hong Kong and Canada, would that be alright? So I want to ask, for the original paragraph D, does it mean someone is practicing their profession exclusively in Hong Kong? As long as one is registered in Hong Kong, you would think that they are practicing their profession in Hong Kong. So is it the case that you only adopt the threshold of one being registered in Hong Kong and that would suffice? I am not very familiar with the registration procedure, so I want to clarify this. Mr. Derek Lee, your understanding is correct. For paragraph D, we want to not focus on whether one is practicing their profession in Hong Kong. That is, if one has left Hong Kong, they will no longer practice their profession in Hong Kong. The intent is that if one is not practicing in Hong Kong, we should revoke their registration. And paragraph D is actually confusing in this regard because the focus is not about one practicing in multiple places. Instead, it should be that one is no longer practicing in Hong Kong. So if one has failed to obtain a practicing certificate within 6 months, we would think that they are not practicing in Hong Kong. Well, so one has immigrated, even if one has registered in Hong Kong, you will still allow for that. We do want to retain talents. So as long as one is registered, one can be regarded as practicing their profession in Hong Kong, right? Right. Alright, that completes the scrutiny of section 10. Let's move on to page 18 of marked up copy, section 12, persons who are qualified for full registration. We, for this section, want to say who are qualified as allied health professionals. Then these will apply to those under full registration and provisional registration. So let me say this for subsection 1. Subject to this ordinance, the following persons are qualified for full registration. For paragraph A, it has 2 subparagraphs, 1 and 2. Basically, original subparagraph 1 says hold such degree or diploma or other document as may be prescribed. We consider it more appropriate to say holds the qualification and, as the case requires, has the experience specified by the council to reflect our legislative intent better. And Roman numeral 2, it would say holds the certificate from the relevant board stating that the person has passed an examination. And this would refer to the original subparagraph 1. It says issued by any examining body. And this actually is a reference to Section 29(1)(be). The Secretary for Health may prescribe legislation for Section 12(1)(a), the qualifications and experience required. This is an existing provision. So for the qualifications and experience that are recognized, say for the MLT board, we have a list of qualifications set out very clearly what degrees are recognized. These under existing arrangements are set out in subsidiary legislation, and one has to pass a course recognized by the board to become an MLT, and the MLT board has to consult the board members before promulgating the recognition arrangements.
B. We should refer to Section 29(1)(be). There will be some amendments which we'll cover in a moment. The Council will have regard to the experience and the qualifications of the person put these people into the register, and in 29(1)(b)(c) provides that the Council can, by notice published in the Gazette, the qualifications for Section 12(1) and Roman numeral 1. At the moment, things are rather cumbersome. All the qualifications and experience will be recognized by the Council, and then we have to amend the subsidiary legislation before we can invoke Section 12(1)(a) for all these qualifications and experience to be included. The allied professionals have a wide variety of courses, and demand is pretty high, and the number of courses is also high. If we stick with this arrangement by amending the subsidiary legislation, it would be rather cumbersome. So with this amendment, what we're seeking to do is for the Council to, by a notice published in the Gazette, recognize the experience and the qualifications and so on. The Council would amend the legislation. In future, it remains the same and nothing is changed. The only change is previously we had to amend the subsidiary legislation for the courses and qualifications to be amended. But with the amendment, it can be achieved by a notice in the Gazette. The legal advisor had also picked up this point, and she raised why we have to make this arrangement by a notice in the Gazette. And let me say this once again. Over the past decade or so, the demand for allied professionals has increased, and there are so many institutions that have already opened so many courses for accreditation by the Council, and the Council has been doing that over the years. Like there are 8 courses to do with the medical laboratory technologists. And accreditation has already been done, but it would take quite a bit of time for the subsidiary legislation to be amended. Until that happened, we will resort to 12(1)(b) to award the recognition. Now, this is not a clear arrangement, so we'd like to have 12(1)(a), where we enumerate all the qualifications and experience. If we stick with the subsidiary legislation to specify the qualification, it would be really time-consuming. So in Section 12(a)(1), the Council can, by a notice in the Gazette, specify all these qualification and experience instead of resorting to the route of subsidiary legislation. Recently, when we amended the legislation relating to nurses and dentists, we adopted the same arrangement. Last year, we amended the 168 for registered nurses and enrolled nurses. We have similar amendments. So this is a way to streamline the entire process. Perhaps DS might wish to add? No. Roman 1. Previously, it is prescribed by board. Now, the power has been elevated to the council. Any specific reason to transfer the power? Let me say this in simple terms. It's not for the board to decide on the qualifications. This is not sufficiently clear. If you look at the Chinese version, the relevant authority specifies the qualification. Now, previously is for the council to specify, and the council would consult the boards in doing so. And we need to have the qualifications awarded by the relevant institutions. So previously, it would be for the council to determine this, and with the amendment, it would still be the council that would decide on the qualification. It would not be the board. Yes, Chairman. Now, the provision was couched in such complicated terms because when the legislation was enacted, some of the qualifications would be recommended by the boards. So when the legislation was enacted, the intention would be for the council to recognize the causes, or the institutions to award the qualification. This is all very confusing. After so many years, the boards do not really nominate the qualifications. And the way it is counted at the moment, it is rather confusing. When we recognize the local qualifications, it's not sufficiently clear where the legal backing is. So we make it clear that these are the qualifications specified by the council, and we don't have to do this via subsidiary legislation. Right, let's finish section 12. Yes, section 12(1)(b). In 12(1)(a), right now we do this via subsidiary legislation. Until we change the law, we would resort to 12(1)(b). And this is also one of the means to recognize the qualifications. Section 1B is meant to recognize overseas qualifications. So a person who holds such degree, diploma of any examining bodies, which together with appropriate experience may from time to time be recognized by the council, and in doing so, the council may consult the relevant board. Now, this remains unchanged. And this is another means of recognizing the qualifications. 12(1)(c) is a person who, on the date on which this section commenced to apply to a profession, is practicing that profession. Now, when we come to the temporary registration, we will go into greater detail. These two provisions remain unchanged. And page 0019, subsection 1A, there are some changes there. Here, after the council has recognized the qualification, now in 1B and C, one has the qualification to be registered, and the council will determine in which part of the register the name would be put. Now, determine in which part of the register, not being a part referred to in section 15(8), the name of a person qualified to be registered by virtue of subsection 1B or C. Well, by way of background, for the registers of the professions, there are different parts. Even for the same qualifications, there are different parts. Maybe some of them are degree courses. Others are diploma courses. They would be put in different sections. If one has the degree plus a certain experience, then the names would be put into another section because he would be in a position to supervise other people. For others, they cannot practice the profession unless under supervision. This is the purpose of having different sections in the register. Here in this amendment, we add 12 or 13A6, 13B7, and 15(8). Now, 13A is about limited registration, 13B about temporary register, and 15(8) is about provisional registration. So here, other than limited registration, provisional or temporary registration, if one get the registration under section 12(1) and B, A and B, then the council still have to decide which part of the register the name should be put. This is in 12(1), B and C. The qualifications are recognized, but they have to be put in a specific part of the register depending on the circumstances. So we are making this sufficiently clear that we have the limited registration, temporary registration, and provisional registration, and they are included here as well. Now, for these three registrations, when we come to the subsidiary legislation for the different professions, we would specify that people registered in these categories will be put in a specific part of the register. So that's why we are spelling this out. They will be included. Well, let's finish subsection 2. I extend the meeting by 5 minutes. So 1A, B, The Council shall direct the Secretary of the relevant board accordingly for these purposes. And subsection 2 on page 0019, a person who willfully procures himself or any other person to be registered by making a fraudulent representation, then he would commit an offence. And the penalty is level 2 or 2 years behind bars. Now, the assistant legal advisor has actually made a point here.
個題
The question was for section 12 subsection 2. It applies not only to those under full registration. That understanding is correct. That is for the fraudulent representation made for one to be registered. It applies to all registration pathways. We agree with the assistant legal advisor's observations. We should make section 12 subsection 2 a specific or a separate provision so that it will show clearly that this applies to those under different registrations. So we will introduce a committee stage amendment to make this clear. I'll perhaps stop here. Thank you for your attendance. We will start from section 13 at the next meeting. Any other business? The date of the next meeting. The next meeting will be held on 3rd of June, Tuesday, between 4:30 and 6:30 p.m. Please attend the meeting. This is the end of the meeting. Meeting adjourned.